The Munyonyo Commonwealth Speke Resort, situated in the outskirts of Kampala, the capital of Uganda, precisely along the banks of Lake Victoria, was the venue for the 2019 Fourth Judicial Dialogue organized by the African Court on Human and People's Rights. The dialogue was organized under the theme, "The Role of the Judiciary in Tackling Contemporary Human Rights Issues in the African Continent."
Elections now on the continent, inevitably, at least almost all of them, go to the courts. Issues of terrorism, we've realized that almost all African countries have come up with terrorism laws, and they have impact on human rights. IDPs, refugees, internally displaced people, these are contemporary issues, and by the way, this is a theme of the African Union for 2019.
Some 5 issues were discussed during the dialogue.
The right to fair elections and the problems of migration, displaced persons and refugees, one of the themes chosen, often have a cause and effect relationship. The right to nationality, a theme linked to the rights of the person, a fundamental right, will also be highlighted as the starting point for the realization of many rights. It is this right to nationality that paves the way for the protection of indigenous people's rights and the main and important aspect in the protection of the right to non-discrimination. Can we forget a phenomenon like terrorism that is taking a heavy toll on some countries, making so many victims and threatening the rule of law? These, as well as all the other themes of this judicial dialogue, highlight the important role of the judiciary in the challenges facing society.
Participants at the dialogue were from different walks of life in the human rights and judicial sectors.
This dialogue brought almost about 43 chief justices and presidents of constitutional and supreme courts from 43 African member states. So it was really a very good number of participants. So therefore, the information has been shared now within 43 member states of the African Union. So the fourth dialogue was a successful dialogue in bringing a good number of participants, one, but also by availing the platform for serious and sincere discussions that really allowed our chief justices and presidents of Supreme and Constitutional Courts to share their thoughts and ideas about how to address all of these issues.
Ugandan President General Yoweri Kaguta Museveni arrived at the resort to personally preside over the opening ceremony. He was welcomed by different dance groups. After a series of speeches delivered by the Chief Justice of Uganda, Magunda Katurebe, the Vice Chairperson of the African Union Commission, Kwate Toma Kwesi, and the President of the African Court on Human and People's Rights, Sylvain Ore, paved the way for the opening statement of the Ugandan President. General Yoweri Museveni pointed out that the struggle for the effective enjoyment of human rights in Africa is affected by 2 main challenges, namely the effect of nature on man, as well as man's attitude towards man. He added that until man finds solutions to these challenges, the effective protection of human rights will not be attained. He thereafter declared the dialogue open.
I want to congratulate His Lordship Chief Justice Katurebe for inviting you and you people for agreeing to come. You have done us a great honor, and I wish you good luck. It is my honor to declare the conference open. Thank you very much.
Participants at the 4th African Dialogue in Kampala debated on some major human rights issues that the African continent has been grappling with over the years and proposed the role of the judiciary in addressing them. One of the issues that came out strong during the dialogue was the problem of migration, internally displaced persons, IDPs, and refugees in the continent.
The judiciary in general, at the continental level, regional and also national level, can also address the issue of refugees, returnees, IDPs and migrants or migration by issuing decisions and jurisprudence that will assist to integrate the refugees into the local communities, also assist returnees to claim their properties that were lost, and that will of course prevent new conflicts from happening. So therefore the role of the judiciary is extremely important in this regard.
The right to nationality and statelessness, which is a major headache throughout Africa, also came under focus.
The issue of the right to nationality and statelessness was first of all to encourage not just the regional mechanisms but also the superior courts of record at the national level. In the context of deprivation on the right to nationality, it should not be limited to administrative mechanisms. It should not be something that is done strictly by the executive, but also follow due process of judicial hearing, which also implies fair hearing, in terms of the person who is at the receiving end of the onslaught from the executive branch. And those are key issues that needs to be taken on board, which is why the knowledge, understanding and participation of the judiciary becomes really critical, because the better they understand the key issues, then they are able to give the right kind of judgment.
Participants encouraged African Union member states to adopt and ratify the African Union Protocol on Nationality in order to reverse the growing number of stateless persons on the continent. Debating on the role of the judiciary on terrorism and the protection of human rights, participants agreed that the judiciary should be an instrument to balance the fight against terrorism and the respect of human rights.
You cannot actually protect human rights in a counterterrorism operations, with the judiciary not having a critical role to play in providing the balance between how to protect human rights and also how to allow counterterrorism operations to take place. So judges themselves, in our national courts, need some guidelines. So in my presentation, I pointed out first, there must be a national law on terrorism, prevention and control that defines clearly who is a terrorist, what are the acts of terrorism, and what is the role of the judiciary, in combating terrorism. First, judges also actually need to be guided by 4 principles. First, in their role to balance the two, protecting human rights of accused persons, the rights of victims, and the rights actually of witnesses, they need actually to put on the scale legality as a principle. The second principle which must guide judges, is the principle of proportionality, the principle of necessity. The fourth and final principle, is the principle of non-discrimination. Now, because the judge is an umpire in the middle of the state combating terrorism and accused persons, victims, and witnesses. So the judge does not make a case for either of the two parties. So the responsibility of the judge is to remain in the middle and strike a balance to administer justice without discrimination against anybody.
As concerns the development and rights of indigenous people, emphasis was laid on the role of national courts in protecting the rights of indigenous people. To them, much is already being done.
There is a tremendous development in terms of normative framework as well as institutions. The African Commission on Human and People's Rights as well as the African Court on Human and People's Rights have both adopted very progressive interpretation by saying that Africa has indigenous peoples and that their rights are vulnerable vis-a-vis dominant populations. So that is a very big achievement from the side of the court as well as the African Commission, because it has developed the jurisprudence relating to the rights of indigenous peoples. But in addition to the regional level, we have tremendous developments in terms of progressive countries that have adopted the standards. And I can cite two countries very quickly. One is the Central African Republic that has actually ratified the only convention that has binding effect. Is called the International Convention ILO 169, the International Labour Organization Convention 169. But another outstanding country is called Congo Brazzaville, that has a specific law that protects indigenous people's rights.
The role of the judiciary in election petition and human rights also came under focus. Participants recommended capacity-building programs for judicial officials to facilitate timely decision-making on electoral disputes.
When the Electoral Commission returning officer, for example, say miscount the ballots, and upon scrutiny, it emerges that the person who was declared to have won actually did not win, then you can see arithmetically you can prove that the results were affected. Now, substantial illegality does not always lend itself like that. If, for example, let me take example with Uganda and Zimbabwe. If the Electoral Commission refused to register voters in an opposition stronghold, or if the polling stations in Kampala or in Harare or in Nairobi, where there is the perception that the opposition presidential candidate, for example, has a lot of following or popularity of voters. The poll starts at 4 p.m. and not at 6 a.m. as it was supposed to start. This is an example of substantial illegality. But because those voters did not vote, the petitioner cannot prove that if they were allowed to vote, the result, they would have voted for him, and therefore the results would have been different. I think this is the distinction that Africa should make. It's not easy. It requires an independent judiciary.
The African Union Commission is there to promote election peacefully, credibly, and transparently at the national level. So we have so many treaties, we have so many instruments, we have so many policies that contribute to the promotion of peaceful election. And of course, you'd agree with me that it is important that we try to avoid conflicts and try to avoid disputes during during election, because then that will result, of course, to lack of stability, lack of security, lack of peace, and it will, of course, also damage the economy, damage our societies, and the consequences are really greater than we can imagine. So therefore, the African Union Commission is working very closely with member states to promote a peaceful election in Africa.
The Kampala dialogue was looked upon by many as a big success, taking into consideration the organization and the hospitality of the Ugandan people.
This dialogue has been a big success. I have attended the last two dialogues, but this one has been a very big success dialogue. And I want to thank the government of the Republic of Uganda for welcoming us and for all what they have done for the success. I also congratulate the president of the court, of the African court, and all the team of the registry of the court. Thank you very much for all of you who came to sustain us for this dialogue. to make it a big success.
On the sidelines of the dialogue was the organization of the first International Human Rights Forum. It was crowned with the signing of a Memorandum of Understanding between the African Court on Human and People's Rights, represented by its president, Honorable Justice Sylvain Auré, and the representatives of the European Court on Human Rights and the Inter-American Court of Human Rights. The three parties agreed to collaborate in different areas to promote human rights, notably through consultation and cooperation, joint actions, staff exchanges, dissemination and exchange of information, among others. The Kampala Dialogue was also an occasion for the African Court on Human and People's Rights to organize a media training for journalists drawn from all over the African continent. The idea behind the training was to sensitize journalists on how to strengthen and popularize the African Union human rights protection mechanism in their different countries, as well as to promote networking and sharing of experience in court reporting and human rights stories. Journalists at the training were reminded that at the moment, only 30 countries out of 55 that make up the African Union have ratified the protocol creating the court, and amongst them, only 9 have deposited their declaration.
The protocol was adopted in 2014. It has been signed by, I think, 11 countries so far. There has been no ratification so far, but you have to understand that the process of ratification takes time. It has to deal with sovereignty. Before a country ratifies a particular international instrument, they need to undertake certain studies at the domestic level to ensure that the international instrument they are ratifying is consistent with the domestic law that they have. Otherwise, it means they have to amend their domestic law to ensure that whenever they ratify the international instrument, they should be able to implement it or domesticate it. We are trying to find out, to understand why there is this reluctance to ratify or make the declaration. We have been engaged in what we call a sensitization mission. We visited about 30 countries now to encourage them to ratify, to encourage them to make the declaration. But you have to understand that ratification or making a declaration is a sovereignty issue. It's something that states need to really take their time. Some states take their time to be bound by international instruments.
The journalists were urged to sensitize their governments to ratify the protocol and to deposit their declaration to permit individuals and non-governmental organizations to seek redress directly from the court whenever their rights are violated.
If an African country is boasting of respecting human rights, there should be no reason why they should not ratify the court protocol and make the declaration.
We try to go around Africa to sensitize the leaders so that they can deposit that declaration to allow individuals and the NGO to seize, to have direct access to the court. As I told you, there are various reasons. Lack of knowledge of that declaration. Sometimes you cannot believe, but believe that or not, but it happened that some governments don't know that there is that declaration to be made, although you have made the ratification.
In all, the 2019 Fourth Judicial Dialogue in Kampala, Uganda ended on a positive note, with over 430 participants expressing their thanks to the African Court on Human and People's Rights for organizing the dialogue, as well as the European Union, the GIZ and the African Union Commission for their support.